Hello and welcome to JSA podcast. I am Sidharth Sethi, and today with my colleague Venkatesh, we are going to discuss force majeure as a concept and its use and implication in LNG contracts, where more often than not, this clause is hidden deep in the boilerplate of contracts, unnoticed and rarely discussed until a contingency occurs, resulting in scrutinization of words used in the agreement. The current global environment, marked by escalating geopolitical tensions, armed conflicts, shifting trade policies, has created significant uncertainty for businesses and governments worldwide. Ongoing wars in key regions, the increasing use of economic sanctions, and the resurgence of protectionist trade measures, including tariffs and export controls, have disrupted global supply chains and altered established trade routes. These situations have led to revisiting of the force majeure clauses in various contracts.
Hello, I'm Venkatesh. As Sid mentioned, the current geopolitical scenario has fundamental impact on international commerce, particularly in sectors that rely heavily on cross-border manufacturing and logistics. Industries such as energy, including petroleum and natural gas, pharmaceuticals, chemicals, electronics, and automobiles, and commodities have experienced volatility due to restrictions on trade, supply disruptions, and fluctuations in logistics and commodity prices. Additionally, the growing trend of economic nationalism and strategic decoupling among major economies of the world has further complicated the stability of long term commercial arrangements.
So, what is force majeure? Black's Law Dictionary defines this expression as a superior or irresistible force meant to protect parties in the event a part of the contract cannot be performed owing to causes which are outside the control of the parties and which could not be avoided by exercise of due care. The expression is not defined in our Indian statutes, but as a concept, it is governed by the Indian Contract Act of 1872. Insofar as it is relatable to an express or implied clause in a contract, it is governed by Section 32 of the Indian Contract Act, that is, enforcement of contracts contingent on the happening of an event. And insofar as a force majeure event occurs dehodes the contract, it is dealt with by a rule of positive law under Section 56 of the Indian Contract Act. That is, contract to do an act which becomes impossible or unlawful. Careful drafting and interpretation of force majeure provisions is essential to determine whether the current geopolitical events can excuse or suspend contractual performance. In commercial contracts, effect of force majeure depends on what the parties agreed upon, and hence it becomes relevant to consider the language of the clause to determine if a specified event has occurred and establish a connection between the event in question and the actual non-performance of the contract by a party. The force majeure clauses generally include acts of God, natural disasters, epidemics or pandemics, wars, strikes, and lockouts. The law in India has been laid down in the seminal decision of Satyabrata Ghosh versus Mugni Ram Bangar and followed in later judgments such as Alopi Prasad versus Union of India, Nehati Jute Mills versus Hyali Ram Jagannath, and more recently, Energy Watchdog versus Central Electricity Regulatory Commission. The fundamental principles laid down in these judgments are: number one, the word impossible used in section 56 does not mean physical or literal impossibility. 2. The performance of an act may not be literally impossible, but it may be impracticable and useless from the point of view of the object and purpose of the parties. 3. If an untoward event or change of circumstance totally upsets the very foundation upon which the parties entered their agreement, it can be said that the promisor finds it impossible to do the act which he had promised to do. However, the performance of a contract is never discharged merely because it may become onerous to one of the parties on account of an unforeseen turn of events. The doctrine of frustration must always be applied within narrow limits. In an instructive English judgment, namely Saki Golu versus Nobly Thor GmbH, despite the closure of the Suez Canal and despite the fact that the customary route for shipping of the goods was only through this canal, it was held that the contract of sale of groundnuts was not frustrated, even though it would have to be performed by an alternative mode of performance, which was much more expensive, namely that the ship would now have to go around the Cape of Good Hope, which is 3 times the distance from Hamburg to Port Sudan. In other words, a force majeure clause will not normally be construed to apply where an alternative mode of performance is possible.
In terms of the LNG contracts, force majeure clauses, or FM as it's generally referred to, is required to be carefully reviewed to determine whether relief may be claimed under the relevant clause. It is also important to consider the identity of the counterparty. For instance, whether the agreement is with a trading entity or directly with an upstream supplier. Since LNG contracts are often structured differently depending on the nature of supplier. Typically, LNG supply agreements require certain minimum thresholds to be satisfied for a FM claim, including that the event must be beyond the reasonable control of the affected party and not reasonably avoidable. Second, the event must not arise from the direct or the indirect breach or fault of the affected party. And lastly, the event must prevent, hinder, or delay the affected party from performing its contractual obligations. Further, the affected party claiming FM must issue notices as required under the contractual provisions to be able to invoke the relief under the relevant provisions of that contract. In the specific context of the disruptions in the Strait of Hormuz, an important legal consideration is whether the seller could still deliver LNG through alternative routes or logistical arrangements, even if this involves additional cost or operational complexity. Many LNG contracts expressly provide that an increase in the cost of performance alone does not constitute FM. Another factor is the structure of the supply chain. For instance, if the seller is sourcing LNG from an upstream supplier that has itself declared FM under its contract, the seller may, depending on the contractual provisions and any back-to-back arrangements, also seek to invoke FM in its downstream LNG supply agreements. In view of recent developments indicating that 2 Indian LNG tankers were permitted to transit through the Strait of Hormuz, it becomes all the more relevant to analyze how the Indian companies may successfully invoke FM on ground of impossibility of performance. This is an emerging situation which requires not just review of existing contractual arrangements, but also serious deliberations on potential options, given that any such arrangements typically will involve large number of stakeholders.